and an ounce of prevention is better than a pound of cure. And a lot of times it's management problems. It's a failure to manage risk effectively that leads to a legal problem. And then you are forced into litigation, and now you're trying to cure a disease instead of avoiding ever contracting that disease.
Yeah, because I know cure is a term, and I'm definitely going to get into what motivated you to get where you're at. But I know cure is a legal term. But I just heard you associate it with what you would think to associate it with a biological cure. In your studies, is that the way your instructors conveyed it to you and your colleagues or your class? All right, think of a legal cure as curing a disease.
Actually, no. That's just how I approach it. I think analogically, and the law does too. We use analogies and metaphors, and as a writer and a poet, I think metaphorically a lot. But I am often drawn to the analogy of law as like it's a practice of law, like there is a practice of medicine. It's not a perfect analogy because there are really important differences. Namely, the adversarial nature of law, you don't get in medicine. There is no doctor that's trying to make you sick.
Well,
whereas there is an opposing.
Unless you're wearing a tin hat, right? But go ahead.
Yeah, right, exactly. But yeah, like doctors are all trying to heal everybody. The first oath is do no harm. Whereas attorneys, if that's the opposing counsel, you should not talk to that person. Everything you say is going to be used against you. They're looking to find fault. So, that's the main difference between law and medicine in terms of how the public reacts with us and interacts with us. But I think that the analogy is pretty good because, one, we have a fiduciary duty to our clients.
Mm-hmm.
We have to put your interests ahead of our own. So a doctor and a lawyer can't say you should do X because it benefits them.
Mm-hmm.
It has to be in the right interest of the client. It has to be in their interest. Another thing is that it's a learned profession. You have to know a lot in order to competently practice. 3, it's self-policing. There's a bar exam. There's a licensing requirements for both doctors and attorneys. It's an ongoing learning requirements, and it's self-policing to maintain the highest standards of professionalism. Requires practice, and it's an art as well as a science. So there's a lot of analogies between the practice of law and the practice of medicine. But I think that from a business owner's perspective, you want to try and prevent a lot of risks if you can. Some of them are unavoidable, and it's just a question of how well do you manage that. But I would encourage entrepreneurs to consult with an attorney about your prospective hypothetical conduct before you go down that path. Talk it through, forecast what the risks and benefits are, compare different strategies, go through your decision tree, and then make that decision based on sound legal counsel. And there you will avoid a lot of risks instead of going down that path, getting into a legal problem, and now you have to go to court and sue and hope that you win, where your fate is in the hand of the judge and the jury. You can have the best lawyer in the world, but if the facts aren't on your side, there's only so much you can do with legal resources. And a lot of problems between, bitter litigants that didn't want to talk things through and solve things informally. The only people that win in those conflicts are the attorneys for both sides. They're the ones getting paid. And the business owners just keep shelling out money to their litigators until they get tired of it and then they settle.